Hey guys, and welcome to my video on gross negligence manslaughter. Sorry, I haven't posted one in a while. This is the first of two videos for involuntary manslaughter. There's gross negligence and there's lawful act manslaughter. Sorry, I have to yawn. So I've typed up a lot, so as usual. This is the answer I use, and it's been very helpful for me. So I'd just like to share it with you guys. You might have some disagreements on it, but this is just my view. As always, downloads in the description and Facebook as well. You can just contact me there. So let's start. Regarding wherever you see the lines, this is where you put the defendant's name in the scenario. Okay. So regarding liability, she or he may be charged with gross negligence manslaughter. The actus reus of GNM is the death which has resulted from the negligent act. Simple definition: alle actus reus. So, in Anamarco, the anaesthetist failed to notice a disconnected test tube during operation. He was convicted of GNM. Then disestablished the test of GNM. So as always, highlighted the cases in blue, so it makes it easier for it to stand out. Then you go for the test. The first element to prove is that a duty situation exists between the defendant and the victim. WQ v. Stevenson is a key case in negligence as it established the key principle in relation with duty of care, the neighbour test. You owe a duty of care to those persons so closely and directly affected by acts or omissions. Then you explain the neighbour test in relation to duty of care. Then you go into normal cases for general knowledge. In Litchfield, the contractual duty of care was owed towards the crew by the ship owner. 3 crew died and the ship was driven into rocks. In Wacker, the duty of care is owed for the purpose of manslaughter, even though the victims were complicit in a crime. So basically that case where there were illegal immigrants, I believe, in the back of a truck. And then you put the name, owes the duty of care as she or he has created a state of affairs which is threatening to life. You apply evidence. You can add con v con if it's in relation to not calling for medical help or other cases if you need to. Make sure you apply to the scenario here, like mention the name and what happens and why there's a duty of care. And then you end it off by saying thus assuming duty of care. So that's duty of care paragraph. Secondly, it must be proven that this duty was breached. The defendant lists tests against what an ordinary and prudent individual would or would not have done. In Becker, the doctor had not fallen below the standard expected from an ordinary and reasonable doctor, so that's plain and simple. In this case, breached their duty well. Let me just explain that. The jury must consider whether the breach of negligence is enough to satisfy a criminal conviction. Bateman rules that the jury must consider whether the breach goes beyond the matter of mere compensation and so such disregard for the life and safety of others to amount to a crime. Then you link that Bateman test to the scenario, so you say, in this instance, Ali's actions go beyond the matter of mere compensation as he, I don't know, slapped someone or something. You just write that down and then link it back to the fact if it goes to satisfy a criminal conviction. The breach must carry an obvious risk of death. For example, in Misra, it was stated that by failing to diagnose the patients, the doctors were risking death. In R.V. Singh, it was held the circumstances must be such that a reasonably prudent person would have foreseen a serious and obvious risk, not merely of injury or even serious injury, but of death. So that's a good case to go with the risk of death. In this instance, there was an obvious risk of death. Well, then you apply. It must also be proven that gross negligence was the substantial cause of death. In Finlay, or Finley, whatever you say, a Boy Scout died on Sloanel, so Sloanel capital because it's a place, or mountain actually, but the Scoutmaster's conduct was enough to amount to gross negligence. In Edwards, the parents allowed their children to play on railway tracks. The parents were both guilty of manslaughter as their children were killed by a train. In this case, gross negligence was a substantial cause well. So pretty simple, it's basic stuff. The last part's a bit more different. Okay. Lastly, you start it off with the actus reus as normal, so you go from the actus reus and then you end it off with the mens rea. So, lastly, the mens rea is the defendant's grossly negligent behaviour. In attorney's general reference number 2, the physical conduct of the accused may be enough to prove gross negligence. You start off with Adamarco and you end it off with Adamarco and the four states of mind. States of mind, mens rea, the guilty mind. Indifference to an obvious risk, actual foresight of risk, and appreciation of the risk with intention to avoid it, and inattention or failure to address a serious risk. Now, I've highlighted this in green because it's up to you to apply it to a scenario. So, in this scenario, Bob had actual foresight of risk because it is virtually certain if you kick a cat, I don't know, if you kick something, then there's a risk of serious injury or death. You could say Bob had an indifference to an obvious risk as well. Bob had an appreciation of the risk, or there was inattention or failure to address it. Make sure you don't mention all of these, you only mention one. So just say there was an actual foresight of risk, but you have to mention four of these: indifference, actual, and appreciation, and inattention. But you only link one of them to the scenario. So you would say that he had an actual foresight of risk if it's most applicable. Then that's how you get the application marks for that aspect. So this is my gross negligence model. Hope it helps you guys. Nothing more to say. Download it in the description if you want to download this and use this for yourself, as always. And hope you've enjoyed the videos. See ya.